because we're on somewhat uncertain legal ground, with the net neutrality order itself, we can't exclude a surprise coming from the D.C. Circuit Court of Appeals and further narrowing the scope of this. All of a sudden, you would see the, for wireless providers, you would see the FTC get jurisdiction again in midstream, and it's possible that there will be litigation on this underlying regulatory fact that's triggered this rulemaking.
Well, the whole thing could be thrown out.
Right, or the whole thing could be thrown out.
It is being explanations of what it is that they want to do with your data before you opt in to give permission. I mean, and I think it ought to be an opt-in. You think it ought to be an opt-out, I guess.
I think that's probably where we are.
You both talked about being part of a process before on privacy. Would it make sense for everybody just to get everybody in the room, the consumer advocates and the public interest groups and the ISPs, and have a big discussion about this, and maybe there could be an agreement on rules, and that would obviate the need for the FCC to impose regulations?
I think actually that probably would not work, but I'll tell.
I would agree with you; it would not work. I think we proved that.
Well, but I'll give you an example. John and I tried to work, and I devoted a lot of time and effort to a process where a set of short-form notice guidelines should be developed so that consumers could make choices about whether to use a mobile app before downloading it. And what I found in the process was that a number of the privacy advocates, and you were working with them, really didn't want to tackle just that problem, and didn't want. I don't think really were that interested in this effort being a sort of broad consensus agreement, because they had other things that they wanted. So it was a negotiation. On the other side, I found that the business community was concerned about being very prescriptive. In the end, a code was put forward, and Apple, BlackBerry, Google have all moved to do slightly different types of short-form notice. In the end, I think that gets consumers, and to require that before apps can be downloaded, that gets Amazon's done the same thing. That gets consumers to a place of receiving short-form notice, but maybe not in the exact way that was agreed to on the it was on the face of the code, but the same place. On the other hand, I found that the consumer advocates didn't really want to have a compromise because they want opt-in privacy rules in different places, and so they wanted to push for broadly addressing that. It becomes much harder to come up with deals that are on very broad questions. It's easier on narrower questions, and this took about a year. But I think that the process that would take to yield an agreement on the whole universe would be feasible, but it would take several years, and I don't think that regulators are going to wait for that, honestly.
I think that the multi-stakeholder process, as they call it, may sound good, but I think that in order to really get something done, I think you need to have a formal rulemaking, and that's what this particular thing that's coming up will be, presumably. And there's a big difference between a bunch of people sitting around a room, all with various vested and competing interests, trying to come up with something and sort of agree. I think a formal rulemaking is a much better way to go. And I think our experience showed that.
Well,
frankly.
I don't think that's always true, but I think in this situation, it's what's going to happen. And given the limited amount of time left in this administration, I don't see a sort of mediated effort to come up with this in the short period of time.
Are we going to see a big fight at the FCC on this? It looks like things are breaking down politically, sort of like they did over net neutrality, with the Republicans on the commission very opposed to some of these rules, and the commission majority really wanting to move forward. So, do you see this sort of mirroring the net neutrality battle once it gets before the commission?
I think this is a little bit more complicated an issue from a public policy perspective. There's a very strong argument that for the FCC to move forward, doing something different than the FTC has done, would be arbitrary. There's a very strong argument also that Internet access providers who now are absolutely required to carry all traffic should not be able to do things that thousands of other players in the Internet ecosystem are doing with regard to advertising for their broadband services, over their broadband services. I think there also are legal questions here that are pretty complicated if indeed the net neutrality rule is struck down as to wireless providers. And all those things may create a more, I think, a more supple political alignment at the FCC, and I'm hopeful we'll work toward finding solutions that really are practical, consistent, and clear to consumers, and based largely on the FTC framework. I'm not sure that that's what will happen, but that was the framework that applied previously. The FCC could then enforce it with much stronger penalties. The FCC has been very aggressive in enforcing lately, and I think Jim likes that. I mean, one again can question whether that's arbitrary because other entities are not subject to that, but whatever final set of rules would result would be enforced, I think, vigorously, and there's no question about that in light of the recent enforcement record at the FCC. So there is, I think, a middle way here, and I'm hopeful that the commissioners, when they really think about this and look broadly at the Internet advertising market, which, again, the ISPs are tiny players in, they'll decide that doing something that's closer to the FTC framework makes sense.
John Simpson, you get the final word today.
Well, I agree that it's a complex issue. I'm not sure that it would play out exactly the same way. We'll get a better sense of that in a few weeks, I think, when the rulemaking is open and we start to see the comments come in. It is a complex issue.
John Simpson, a former journalist, is with ConsumerWatchdog, where he is the Privacy Project Director. Jim Halpert is a lawyer with DLA Piper, covers privacy and cybersecurity matters. And Howard Buskirk is Executive Senior Editor of Communications Daily.
C-SPAN, created by America's cable companies 35 years ago, and brought to you as a public service by your local cable or satellite provider.
On the next Washington Journal, we talk to North Carolina Congresswoman Virginia Foxx about the Republican agenda and the 2016 campaign. Then Florida Congresswoman Kathy Castor joins us to discuss U.S. policy towards Cuba, including the Obama administration's decision to restore diplomatic ties with Havana. You can join the conversation by phone or on Facebook and Twitter. Washington Journal live each morning at 7 Eastern.
The Supreme Court is vested with this outsized amount of power, and with that power comes greater responsibility, and the idea that you have individuals sitting on the court for unfettered for 30, 35 years is just doesn't pass the smell test when it comes to a modern democracy.
Sunday night on Q&A, Gabe Roth, Fix the Court Executive Director, talks about changes he'd like to see at the Supreme Court, including opening up oral arguments to cameras.